So once again, peace be unto you, and welcome to this evening's edition of the NUPGE University of Ghana Alumni Seminar Series. My name is Emmanuel Labiofe, the NUPGE Alumni Organizer. I will now invite the Vice President of the NUPGE Alumni, Mr. Kwame Adomako-Kwabia, to give us the opening prayer.
Okay, good evening. Shall we pray? Merciful Father, we thank you for the opportunity for life from the beginning. As we commit this, you've come guide us through. May not just be a mere time for talking.
We want to thank Mr. Kwabia. Sure, we had a difficulty because of probably network challenges. Please bear with us. And we, in one accord, want to agree with the prayer that Mr. Kwabia has said in spirit and in faith, and say that we thank God for an answered prayer. In the name of Jesus Christ, we pray. Amen. I'll now call Mr. President of the alumni in the person of Mr. Kwesi Opoku-Mintah to give a very brief address to this session.
Thank you very much, Mr. Labi. NUPGE, we want to welcome all of us again for our virtual session. And as our moderator said, today is about the law. The lawyers will tell you ignorance of the law is of no excuse. So today we have distinguished lawyers amongst us who are also part of the NUPGE family, who are going to take us through the law of succession. So I want to welcome all of us, far and near, to listen to our lawyers, jot our questions down, and let's have a very fruitful deliberation. Once again, you are all welcome. Thank you.
Thank you very much, Mr. President Kwesi Opoku-Mintah. Let me proceed to introduce the moderator for this evening's event. So our moderator for this evening is in the person of lawyer Ayeyi Ansah. Lawyer Ayeyi Ansah is an alumna of the University of Kwame Nkrumah University of Science and Technology, where she obtained her first degree in law in the year 2017. She subsequently enrolled in the Ghana School of Law in the same year and was called to the Ghana Bar Association in the year 2019. Since her call in 2019, Ayeyi has actively practiced as a lawyer in various capacities, and presently, Ayeyi works with the legal unit of the Presbyterian Church of Ghana at the head office in her capacity as the assistant legal officer. She is a Presbyterian and worships with the Accra Ridge Church. Thanks for accepting to moderate this evening's conversation, and the floor is yours.
Thank you too. Good evening. I don't know if you can see me. I have my video is on, but I can't tell if you can see me.
I
Please
can
let me know if you can hear me. If you can see
I
me.
can see you and I can hear you, so you are good to go.
Okay. Good evening, everybody. So as the moderator has already mentioned, this evening we'll be speaking on the law of succession and preparation of wills. And we have one of our speakers in the person of Mr. Lawyer Richard Dua Ansah on the call. Okay, I see that Lawyer Kennedy Efa has also joined us. So I'll just give a brief summary of who Lawyer Richard Dua Ansah is. He will start with the law of succession, and Lawyer Kennedy Efa will continue with the preparation of wills. But I'll introduce him when it's almost time for his. Lawyer Richard Ansah completed his first degree in political science and philosophy at Legon in 2006. He was a director of the Nujid Levites Choir during the 2004-2005 academic year. He later acquired his law degree in 2009 at the then Faculty of Law of the University of Ghana and proceeded to the Ghana School of Law. He was called to the bar in 2011. He pursued a master's degree in intellectual property from African University, Zimbabwe, and is currently pursuing a PhD in law at the University of Ghana School of Law. Mr. Dua Ansah lectures at the UPSA Law School, and he is a legal officer at the PCG head office. He fellowships with Nantoma Congregation Kanda, where he is the clerk of session. Lawyer Richard Dua Ansah will be grateful if you could start your presentation on the law of succession. Thank you very much. Lawyer Dua Ansah.
All right, thank you very much, Ayi, for that introduction. I am basically, as has been indicated, I am essentially going to give an overview of the law on succession. Of course, it's a whole course, it's a whole semester course, and so we certainly cannot cover all the aspects of the law of succession, but we'll try to bring out the key issues as far as succession, the law on succession is concerned. And then my learned friend, Chairman Efa, would also take it from there. Now, when we talk about succession, essentially you're talking about who wears your shoe when you are no more, or if you like, who inherits your property, your self-acquired property when you die. Of course, all of us are going to die one day if Christ does not come during our lifetime. And so the law makes provision for what happens to your self-acquired property when you die. And I repeated the terminology self-acquired property because in law, we say that you can't give what you don't have. And so if you co-own a property with another person, your spouse, you cannot give the entire property to somebody else without the consent or without the agreement of that other person. So the thing is about what happens to your property when you die. When you die. Now, things you have the option of choosing, or if like indicating or determining who takes your wristwatch, or who takes that parcel of land of yours, or who takes that vehicle of yours when you die. You have the option of doing that. And then, but if you don't do that, the law has made provision for how that is administered. Now, whatever we are going to discuss, myself and Chairman Efa, are essentially going to be from the Administration of Estates Act, from the Wills Act, if you want to prepare a will, which Chairman Efa will talk about in detail, or the Intestate Succession Act, which regulates how your properties are distributed when you die and you did not make a will. Now, as I said, you have the option of choosing that when I die, my properties go to A, B, and C. But if you don't do that, then there's a legal regime that regulates how your properties, your self-acquired properties, are administered when you die. Now, if you died without making a will, then your properties will be administered according to PNDC Law 111, which is the Intestate Succession Act. And according to that law, a portion, these persons can apply for letters of administration from the court to administer your estate, either your spouse or your children, any of your children, or your parents if they are alive, or the customary successor. So these four categories of persons are those who are entitled to go to court to take what we call letters of administration to administer your estate. By law, if somebody dies and letters of administration or probate is not procured from the court, essentially, if somebody dies and you don't get a certificate from the court that authorizes you to administer the estate of that person, and then you go ahead and intermeddle or you meddle in the properties of the person, that is actually a criminal offense, and you can go to jail for that. So it's unlawful to touch people's properties when they have died without taking authorization from the courts. Now, the person died without making a will. Then, like I said, those four categories of persons, any two of them, or even any one of them, or any four of those categories, spouse, children, spouse, child, parent, or customary successor, could go to court to apply for the grant of letters of administration. And that letters of administration essentially empowers you, the administrators, to share the properties according to the PNDC Law 111. And the 111 Law 111 will say that if somebody dies, 9/16 of the person's property goes to the children. And then 3/16 of the person's property goes to the spouse. If there are multiple spouses, they share the 3/16. And then there is left with 4/16. 2/16 goes to the parents if they are alive, and then 2/16 goes to the family according to custom. It's administered according to custom. So that goes to the customary successor, and then it is on behalf of the family, so to speak. If the parents are not alive, then the 2 that was to go to the parents will be added to that of the family. So 4/16 will go to the family. But normally that one, the administrators will be guided. If they are guided by a lawyer, then the lawyer will guide them to administer it according to the law and then file an account of their administration to that effect. Now, I mentioned that succession is basically who takes, how many minutes did you give me so that I... Otherwise, I may go on and on, but if you can hear me, just let me know how many minutes you have given and then...
Okay, sorry, I was struggling to unmute myself. Yes. So, Tina, you have about 20 minutes for your presentation. Yeah.
Okay,
You've done about 7 minutes, yes.
All right, thank you. Right, so we're talking about when you have died without making a will, the appropriate people are led by a lawyer to go to court and get letters of administration. Of course, you can go to court to get a letters of administration without using a lawyer, but it is normally safer, especially when there are multiple properties involved and multiple stakeholders. It is always important to be guided. You do it, you get the letter of administration, you distribute it, and then you file it in court that this is the account. You render account and then you file it in court. Then nobody will later come and worry you about how you did not comply with the requirements of the law. Now, if you are an administrator, it's a legal duty on you to ensure that you share it according to law, and then you file the requisite reports. Now, so you have died without making a will. That is what happens. Now, when you are about to die, and well, sometimes you get to know that you are really, really dying, and it can happen that you are not, you want to determine who takes which aspect of your property, but you're on the sick bed and you cannot go through the process to make a will. So if that's the situation, you can still make a determine who takes what, but it has to be in the presence of witnesses who can later vouch for whatever you have said. And you can even scribble something and then append your signature or mark on it if you can. If you cannot, you can indicate it in the presence of witnesses who will later attest to the fact that you wanted this particular property to go to that person, or you wanted this particular wristwatch of yours to go to that person. So those ones are allowed. In fact, we should know that in Ghana, customary law is also part of our laws, which are valid and binding, and they are binding to the extent that the courts have made pronouncements on them. So customary law, customary will, and customary way of sharing your property is also allowed. Another way to determine who takes what is to even share it before you die. So you don't wait, you don't make a will. The will will take effect only when you are dead. But you can do a deed of gift to whoever you want to give it to before even you die, so that when you die, it's very clear that this person takes that property and then this person takes that property. Now, when I started, I was emphasizing self-acquired property. And it is so because sometimes you can jointly acquire a property with your brother or your sister or your spouse or any other person, your parents, your friend. You know, you can acquire property together with them. And so your portion is what you can give. But particularly when it comes to spousal property rights, it's the law on that in that area is in constant flux, as it were, because the Supreme Court has been I don't want to say inconsistent. It can be said that they have been inconsistent, but if the law is evolving every day, every now and then. And so if properties are acquired in the course of marriage, then they are jointly acquired. If they are jointly acquired, then we say that it's spousal property. And so upon the death of one person, or even without death, when there's a dissolution of the marriage, they share 50-50. But of course, there are decisions of the Supreme Court to the effect that it may not be necessarily be 50-50 like that. You have to show some level of contribution and all that. But we leave that to the lawyers. But the point about succession is that if you die without making a will and you jointly owned property with another person, it is only your portion that will be distributed, that you can determine goes to who. So for instance, you are married and you have acquired a property that can be said to be a marital, spousal property, or not spousal property, I mean jointly acquired property in the course of marriage. Let's say one building, one house. So we assume that both of you contributed to the property, and so half of it will be yours. It is that half that will be subject to the administration of estate, or will be part of your estate, and so can be administered or shared by whoever has taken letters of administration to administer your estate. And then, so if you have a spouse and you die, your portion will be half. In the illustration I gave, your portion will be half. So your spouse could still have a bit of your portion in addition to his or her half that the person has. All right, so that's how that aspect also work. Now, I mentioned that you can do a deed of gift. For that gift, you can do a gift in writing and then signed, and then you do it like you are giving land, you are signing a conveyance, or you are signing a lease or a whatever transfer of interest in land to another person. You can also do a customary gift even before you die. You can also do a customary gift, and then as that is given in accordance with whatever custom applicable, and then that's also binding so long as witnesses are there to attest to the fact of the giving of the gift. Now, when I mentioned spousal property, maybe let me quickly chip in that well, if that property is landed property, then it's also subject to the requirements of the Land Act, which says that actually you can't even do a transaction in relation to your landed property, which you co-own with your spouse. In fact, what the Land Act actually says is that so long as you have a spouse, if you want to transfer any interest in that landed property, you'd have to do it with the consent of your spouse. So if you have a building and you want to lease it out, you have a land, you want to lease it to another person, you need the consent of the other spouse. So if you wanted to give something to somebody, whoever succeeds you, then you have to get a consent of your spouse before you can do that, according to the Lands Act. Now, when you have mostly the disputes arise where people have interest. Now let me talk about let's say shares in a company or other assets that you may have. If it's about shares in a company, the shares, so somebody can say that, oh, this is my company. But if somebody says this is my company, there are a couple of things. The question is whether the company is the duly incorporated company by law. If it is, then you can't really say this is my company. You can own shares in a company. So when you die and you have a company, I'm just using the term loosely, that you have a company. What it means really is that you own shares in that company. You have an interest in that company. So when it happens that you die, your interest in the company can be transferred to whoever you have indicated in your will that it should be transferred to. If not, if you did not indicate that it should be transferred to anybody, then, like I said, PNDC Law 111 will indicate who gets what. So in respect of that, those shares, they will be shared according to the ratio I gave you. And I repeat that, 9/16 goes to the children, 3/16 goes to the spouse or the spouses, if there are more than one spouse. And then it will be left with 4/16. So that 4, 2 goes to the parents if they are alive, and 2 goes to the family, or goes to the customer successor on behalf of the family, if you like. The law says that it will be administered according to custom, the applicable custom. So it goes to the customer successor on behalf of the family, so to speak. If the parents are not alive, then their 2/16 is added to that of the family. The family will certainly be alive and all that. Now, somebody dies. If somebody dies and the person does not have children, the person does not have parents, the person, it's possible, all these are possibilities. The person does not have family, does not have anybody, then the states can take action, can take steps to get the property administered according to law. The Administration of Estates Act makes provision for that. But I mean, we are interested in those of us who want to determine even what happens to their property when they die, and then and all that. Let me also point out that in terms of customary successor, it's also related to succession, because if we are talking about who takes over from you, you find that then you are talking about customary successor, who succeeds you. Now, customarily or by law, it is the family that determines who the customary successor is. Some people sometimes make proposals, and they can only be proposals that when I want this person to inherit me, but it is essentially it is a preserve of the family to make that determination. Sometimes they will respect your views and they will respect your choice, and then they will appoint that person as your customary successor. But you don't have a legal right to determine who succeeds you when you are gone. Now, just a quick history about how where we were before we enacted the PNDC Law 111 in 1985. And prior to that, when you died, your self-acquired properties became family property. And so the family would only allow the spouse or children a bit of the property subject to good behavior and all that. But from the 1985, if you died, the law is clear about who takes what if you did not make a will. If you made a will, then it will be administered or shared according to the requirements of the will. Senior Ifa will be talking more about the will. But just to mention that sometimes you can make a will and then you leave out some people. The law says that there are some category of people that if you leave them out from the will, they can go to court and then get an order from the court to make them part of the beneficiaries of the estate of the person. Finally, I would touch on the estate of the person, and in terms of succession, the estate of the person, and then valid nominations the person may have made. If you died and then you were a SSNIT contributor and you nominated persons to benefit from your contribution, that nomination will take precedence over any other law. Okay, that is to say that if you nominated persons for insurance purposes, in fact, for all insurance purposes, insurance will be based on contracts anyway. But if you were a SSNIT contributor and you contributed to SSNIT and you died, normally they will ask you to indicate who gets how much of your contribution when you are no more. So that indication is binding. Actually, your SSNIT contribution is not part of your estate. It's not part of the things that you died leaving, so long as you made valid nominations for that. It's just that if you did not nominate your spouse or you did not nominate your child below 18 years, those persons can go to court for the court to make reasonable provision out of that contribution, and then SSNIT will be bound to comply with that. But for others, so the other time we're having a discussion with Chairman Ifa, who we know is a banker, is an astute banker and a lawyer. And he was telling us that for the banks, it's different. If you have money in the bank, it's part of your estate. So it is the letters of administration that you take it to the bank and the bank will respect. And then they will give you the money so that you go and share to the beneficiaries according to law. Now, if the person died without making a will, you go for letters of administration from the court. If the person died making a will, then you go for probate. So probate and letters of administration are essentially the same thing. They is the authority that the courts give you to go and share the property of the person according to law. So according to how the person has made a will, if it's a probate, and then according to the PNDC Law 111, if it is letters of administration. I think my time is almost up.
Yes, you have about 30 seconds more.
So I'll use that to take a sip. I'll sip water. So thank you.
Okay. Thank you so much, Ladiansa. I'd like to mention that, like you mentioned earlier, the law of succession is a whole course at the LLB level, so we cannot exhaust all the topics under this course today. But I'm sure that when the time for questions is opened up, we'll be able to throw more light on some of the things that we may want to ask about. So we'll take the question time after the second speaker has taken us through preparation of wills. I would like to introduce the second speaker. He's in the person of Mr. Kennedy Riafi Ifa Esquire. He's a banker and a lawyer in a private practice with work experience spanning over 16 years. He trained in accounting from the University of Ghana Business School, Legon, in Accra, where he graduated with a BSc Admin Accounting with honors in May 2003. He obtained his LLB degree with honors from the Ghana Institute of Management and Public Administration, GIMPA, in May 2015 and was called to the Ghana Bar in October 2017. After his professional legal training from the Ghana School of Law, Accra, Kennedy is a senior associate lawyer with Insia Akwete & Co., an experienced firm of legal practitioners and consultants, as well as notary public. He handles a practice portfolio in immovable properties, banking, labor, and family matters for both corporate and individual clients. Kennedy also serves on the board of directors of the La Community Bank PLC and is also the legal advisor to the Kwewu Presbytery of the Presbyterian Church of Ghana. From December 2016 to October 2017, Kennedy worked with MacWest Limited, a major corporate distributor for Gasem Limited, as head of finance, responsible for budgeting and strategic planning, fund management, and management of accounts and payroll. Kennedy started his career in the banking and finance industry in March 2006 with the Women's World Banking Savings and Loans Limited before joining Intercontinental Bank Ghana in January 2008 and Access Bank Ghana Limited in April 2012 in various capacities, including corporate and retail banking, consumer banking, public sector banking, credit administration, internal control, compliance and due diligence in Accra, Tema, and Kumasi. For voluntary services, Kennedy served as a presbyter of the Presbyterian Church of Ghana, Christ Congregation in Dakuma, Accra, from September 2012 to February 2021. He enjoys playing volleyball or soccer and watching movies as hobbies. So we'd like to welcome Lawyer Kennedy Riafi to the floor. He's taken us through preparation of wills.
No,
Senior, you're welcome. Yes, dear.
yes, thank you. And thank you, Senior Richard, for the presentation. Yeah, so I am presenting on the law on the preparation of wills. Let me.
Yeah, sorry, not to cut you. You have 20 minutes for the presentation because there'll be a question time after. So I'll let you 5 minutes of time through the
Very
chats.
well.
Yes.
Very well. Yes. And good evening to everyone. So I'll move straight to the point on preparation of wills or the law on preparation of will. The first point is that everything comes under the Wills Act of 1971, Act 360. And the judgments or what we call the common law judgments of the court concerning preparing wills. So these are the two fundamental laws that we will look at. So under the Wills Act, a person of 18 years plus can make a will. And the person making the will is called a testator or the testator. These are just legal words. So, but it makes it easier to, sometimes construct certain sentences. The person making the will should not be less than 18 years. And the name we give to the person is testator. Now, the will should be in writing. The will should be in writing. There is an exception to this. In fact, for most of the requirements, there's exception regarding people in the army. People in the army, they have special dispensation when it comes to wills because of the nature of their work. So when we are done with the general provision that applies to all of us, I'll say a few things about the military or those in the army. So the will should be in writing. It should cover your own properties. It should cover your own properties. That's the properties of the testator. You cannot make a will covering something that is not yours. Now, if the property is jointly owned, you say so in the will and indicate that it is your portion that you are giving out. Yes, then the person making the will should be of sound mind. It should be of sound mind. If for any reason there is proof or certification that the person had a mental difficulty, the will not be valid. So that's one thing we should note. Then the will should be made in good faith. A will obtained by fraud, a will obtained by accident, a will obtained under duress is not valid, is void. So the law requires that the will should be made in good faith. The person making the will, the testator, had the intention of making a will. The person intended that I want to make a will of my properties and followed it up by making the will. Other than that, if it is proven, and it happens. In fact, people die at the hospital and people make will and use their thumbprint, to, if you like, sign to see that this person prepared a will. But so if it is proven that the will was obtained by some fraud, it was signed by mistake, the person was told these are cocoa farm documents. He signs and turns out that it's a will. The person signed by mistake, it was under duress. A gun was put to his head. If you don't sign, we shoot you or we shoot a loved one. All those kind of things will not amount to a valid will. So we have to take note. Then one thing that is quite important when it comes to wills is the signing of the will. The signing of the will. It must be signed by the testator. Now, after the signature of the testator or the thumbprint or the mark of the testator, any other dispositions or directions beneath the signature is invalid. It's invalid. Anything that the testator wants to give by way of the will must be above the signature. Must be above the signature. And it's a requirement of the Wills Act that below the signature or beneath the signature, nothing should be written again. And also, if it is proven that an insertion in the will was done after the signature, it is also invalid. So let me give an example. Assuming now, but we use blue pen, black pen, red pen, the auditors use green and so on. Let's say, we keep coming up with strange things and things. For some reason, in some year to come, let's say 2030, it becomes the norm that people use yellow pens. Someone prepares a will in 2023, and it is in blue pen. And it happens that after 2030, there's an insertion in yellow pen. And it is proven that the use of yellow pen actually started in the year 2030. And that it could not have been done in 2023. when the will was actually prepared. You see, there's demonstrable proof that the insertion in the yellow pen was done after the signing of the will. That insertion will be invalid. You see, anything that, whatever means it is proven that this was added to the will after the signing of the will, is invalid. But the rest of the will remain valid. So let's take note. You don't prepare your will, sign it, and you say, oh, I left this one out, and then later you insert it or write it in the will. No. Anything added to the will after the signing of the will, either on the face of the paper beneath the signature or an insertion in the will, is invalid. Then the other thing about the signing of the will is that it must be signed in the presence of two witnesses, who must also witness in the presence of the testator, the one making the will. So that requirement too must be complied with. If at any time it is proven that the witnesses did not see the testator signing the will be invalid. So it happens, there's a dispute. Witnesses are put in the box and asked, how did you sign the will? Well, I was in my house, was brought to me that I should witness. How did you witness this will? I should witness. At the time you were witnessing, had the will been signed? Yes, it was already signed. And I witnessed. You alone, you witnessed in your house. Yes. That is it. Clearly, the witnesses did not see the testator signing. And that's what the law says that it should not happen. The witnesses should see the testator signing, the two witnesses. And the testator too must see the witnesses signing. It's a requirement of the law. Then the other thing is that under the Wills Act, the testator can ask somebody to sign the will for him or her. So the testator can direct someone. And so that must clearly be stated on the face of the will that for some reason, let's say as a result of stroke, the testator cannot use the pen, can direct. If the testator can speak, he can direct somebody to sign. And it must be stated on the face of the will that due to ill health or this or that, the testator directed this person to sign the will. So it must be stated. Then if the testator is blind or an illiterate, cannot read, it must be stated on the face of the will that a competent person read out the will to the testator. He or she, in a language he or she understands, and that the testator signed the will after understanding the content. In law, we normally call it jurat, that on the face of the will, there must be a jurat stating the name of the person who did the reading out and the interpretation of the will to the testator who is blind or illiterate. So that must be done. If you know the one preparing the will is illiterate, you must add the jurat. You must state on the face of the will that this was complied with. So that is on the signing of the will. The other legal requirements that we should take note of concerning the will is that Senior Richard, you mentioned you cannot take out certain people out of your will without reasonable explanation in the will. So by the Wills Act, it is a very popular section known as Section 13, the provisions of Section 13 of the Wills Act. Your spouse, your children, and your parents, if they are alive, you cannot take them out of your will. So you can't make a will, you don't give anything to your spouse, probably because both of you are not in talking terms or the marriage is cold. No. if the marriage is not dissolved, you can't leave out your will. And it is not just putting a name in the will and giving her your notebook or your old mobile phone. The law says that reasonable provision. So what you give to your spouse, your child, your parent who is alive must be reasonable in the eyes of the law. And you know, that leads us into the realm of discretion and judgment. So, I mean, generally, if it is a landed property, a house, land, those ones are considered reasonable. I mean, straight away. But other things, I mean, you prepare a will. Going through the will, you have about 5 properties. And all you give to your wife or your husband is your shirts. You say, okay, I give to my wife all the shares I had. I mean, that will not be reasonable. So the law says reasonable provision. You cannot take them out without reasons or justification. If there's very strong reason why that must be so, you can state it, you state it in the will, you justify it in the will. So let's say a son, I mean, events happen, and a father, is it denounce denounces a son and says that from this day on, I mean, I've given you up. You don't form part of my children. Those of us that relate to our hometowns, it's common. It happens. You have to state it in the will that due to ABCD, this person, I do not consider this person my child, and for that reason, I cannot include, or I cannot make a gift, a disposition to this person in my will. You state it clearly. I did a will in which the man, in the effort to take the 3 children of the marriage outside the country, was made to do DNA, and the results show that 2 of the children do not belong to him, or they were not his children. So in making the will, he stated it, that the wife, whilst he was in Italy in the cold working and sending money home, the wife was unfaithful. So out of the pain, he doesn't think he wants to make a disposition to the wife. He gave his reasons, and it was in the will. So you just cannot leave your spouse, your child, or your parent who is alive out without any justification in the will. That is one. Senior Richard mentioned the issue of insurance. Let's say the property or the funds, the sum insured, whatever you've insured by way of insurance. Whatever you've given to the insurance company as the beneficiaries of that insurance take precedent over whatever you put in your will. You can state something in a will, but if it is at variance with what you've given to the insurance company, that of the insurance company will take precedent, so that what is in the will become a secondary matter to be subordinate to what is with the insurance company. So if with the insurance company, you give your spouse as the beneficiary, and in your will, you now name your children as the spouse will be the beneficiary, because that is what is with the insurance company. The reason is that the insurance is a contract, and the law respects and protects the contract over and above the testamentary disposition. So that is that one. So in terms of the legal requirements, these are the general ones that apply. The military or people in the army have some exceptions. One is that age does not apply to them. If a person is in the army, then irrespective of age, the person can make a will. So the requirement of 18 years plus don't apply to those in the army. As to what the question on your mind, it was also on my mind initially when I heard this word. How can somebody be in the army who is not 18 years? Well, it can happen. Those of us that are familiar with war and the laws in wartime, I mean, during war, anything can happen. Yes, those in the army can make a will that is not witnessed by anybody if the will is in their handwriting. That's the condition, in their handwriting. Then a witness is not required. If it is not in their handwriting, but let's say it's typed out, then one witness is required. One witness is required. If it is not written at all, it's an oral will, then 2 witnesses are required for those in the army. That's the only difference between their will and the rest of us. So I think I can end it here. And then as the questions come, maybe areas not covered will be covered. Thank you all.
Yes, thank you so much, Senior. Thank you so much. The floor is open for questions. You can make use of the Q&A section, or you can raise your hands and then we would unmute you so you can ask your questions. And there are a few questions here. The first question is for the family's share of the interstate portion, has it any preference to matrimonial? Has any preference to it should be matrilineal or patrilineal inheritance systems? So I don't know, Senior, Mr. Diasa, you can answer, Mr. Fa, you can answer whether or not preference is given to the matrilineal or patrilineal systems in sharing the family's portion when the testator dies intestate.
Okay, before my senior speaks, he is senior. If he finished speaking, I can't come in. So let me talk first.
Okay.
Okay, so the Court of Appeal had an opportunity to deal with this matter. I've forgotten the exact citation of the case. But then if you look at the PNDC law 111, it says the divorce according to custom. It didn't say family. So you don't see the word family in the PNDC law 111. It says divorce according to custom. So the Court of Appeal looked at that and said that what it means is that it will devolve according to the custom of the testator.
Okay.
So if it is the person belongs to a patrilineal customary practice, then you follow the patrilineal to inherit that portion. Okay. If it's a matrilineal, that is it. We just assume that because the law said customary, it belonged to the family. No, it doesn't belong to the family. In most patrilineal systems, it goes to the first child or the first child of the person. If it is matrilineal, then it goes to the customary successor, normally the nephew. And by law, once it is in that representative capacity, then it goes to the family.
Okay. Mr. Diasapis, is there anything you would like to add?
Oh, I think essentially that, I mean, the law says that according to custom, so whatever custom that's applicable, if it's patrilineal, then the law relating to patrilineal customary issues will apply, as Chairman has indicated, rightly indicated. Thank you.
Okay. The next question here is what happens where there's a will on part of a person's estate, but the other part of the estate is not covered by a will, and the person doesn't also have any provision for a lapse disposition? How would that be handled?
The portion of the estate that is not in the will go into intestacy.
Okay.
So you apply for letters of administration to administer that portion.
Okay.
And then the portion in the will operate. I left this thing out. It's every will requires an executor or maximum of 2 executors. So there should be at least 1 executor in a will. The executor takes the position of the testator immediately after death. So that's a requirement. Now, the other requirement I left out was that a person who is a witness to a will cannot be a beneficiary in the will.
Okay.
The executor can be a beneficiary, but not the witnesses. Anyone that is a witness to a will cannot have any gifts in that will that the person witnesses. So these are just the 2 things that we should also be mindful of. But for partly covered estate, partly not covered, the portion not covered will go into intestacy. You can use letters of administration to take care of that.
Okay, Senior, just to follow up on what you said, that a beneficiary cannot be a witness. What happens in the event that a beneficiary is a witness to the will?
It will be void. That portion of the disposition will be void.
Yeah.
Okay. The next question is, with the 9/16 going to the children, does it matter if there are 10 children or 1 child? Does it matter the number of children in determining the percentage, the ratio, the sharing ratio for children?
Well, it does not matter. I mean, the law is what it is. So if there are 10 children, they share 9/16. If there's only 1 child, all the 9/16 goes to that child. So it matters not.
Okay. Another question is, where the 3/16 goes to the spouse, is this sharing ratio done after the spouse's 50% portion has been determined or before?
After, if the spouse had, if the property we are talking about, I mean, the spouse had a stake in it as a spouse, that is, if it were a matrimonial property, then the spouse will take half, and then the rest will be subject to. So it may be that rest include together with all other properties that the person left behind, right?
Okay.
Yes. So the 50% is taken out for.
Okay. The next question is, are children taken care of by your parents entitled to any property if there's no will? In this case, no documents of adoption. So they are not biological. They were just taken care of by the deceased person. Will the person be entitled to a portion in the property if the person was not legally adopted?
Okay, maybe let me take a bite first. If the person was being taken care of course, the person is not a child, and so it doesn't come under the children provision. Now, unless there is a legal adoption, that will be handled. But there can be instances where the children can say that even though you're not biological, there's no adoption, but we know that we've been living with you. We know that dad has been taking care of you. We acknowledge you as our sibling. And so once they agree, it can be shared, and then they can also, that person can take part. But by law, the person is not part. But if the children agree, then the person can also take a share of whatever entitlement. In fact, I once did an LA where there was a particular person that had been living with the man or her life living with the children and all that. They all agreed, and so when we were sharing, we just added her to the distribution, and then she was a beneficiary. So once the children who are the beneficiaries agree that we recognize you as such, it works. Otherwise, then legally you will not be part of it. Yeah.
Okay, but the court cannot vary it and term the person as a dependent. In the event that the person is still a minor, yes.
Yes. If the person is a minor, or the person is, if the person is a minor, then the person can prove, of course, because the law says that dependence. The law makes provision for dependence. But maybe let's look at it, Chairman, if for section 13 of the will, if it's about a will, then it has to be a child, a spouse, or a child I don't think that if you are not a child and you are merely a dependent, you qualify. But specific about a child and a spouse under 18 or so. So if that is the case, that being the case, if you are dependent, I mean, yes, you were like any other person, you were being taken care of by somebody, but legally it's not the person's responsibility. So if the person is dead, then maybe you find answers somewhere.
Right. Senior, if please, would you like to add something to this
Well,
question?
I would just say that under our law, a
Yeah.
child includes persons recognized by the person in reference, let's say the one who is dead, as his or her child. You see,
Okay.
so if there's that recognition, whether by formal adoption, whether by custom,
Marrying.
once there's that formal recognition of that person, and after the death of that person, there is some evidence to show. For instance, the name of this child was changed to take the surname of the deceased person. I mean, some evidence to show that the deceased person recognized this child as his or hers during his or her lifetime. That can be sufficient evidence to say that that's a child of the deceased person.
Okay. The next question is, if one has, for instance, 3 wives, will all of the 3
I think
share
maybe I kindly
yeah.
just a quick addition. You know,
Okay.
yes, in Ghana we recognize customary adoption. So it may not go according to the adoption, the court adoption, the formal adoption. So that will, as Ifa has said, then that person will be recognized as a child pursuant to the customary adoption. Yes, thank you.
Okay, thank you very much. If one has, for instance, 3 wives, will all these 3 wives share the 3/16 ratio? The sharing ratio for wives, will all 3 wives share in this portion?
Actually, Senior Rich, let me come
ahead,
in, then
yes.
you take. You know, this has necessitated the current review of PNDC Law 111. I think there's a bill being worked on by the FIDA, the Federation of Women Lawyers in the International Federation of Women Lawyers. Now, it started from the Muslim community. That says that they are permitted to take up to 4 wives.
4 wives, yes.
Now, under the PNDC Law 111, if the deceased person died leaving a house, the house goes to the spouse and children. Now, if there are 4 wives, 3 wives, 2, and children. Okay, so the issue is not even when there's just one house. Assuming that the deceased person had 8 houses scattered across Ghana, maybe 5 in Accra, 3 at home, and all that. The law says that 1 house goes to the wife and the spouse and children. So the question is, should all these 4 wives just
take 1 house?
You get me? So the Muslim community raised this issue severally, that is unfair. But as it is, that is the law. That is the law. Irrespective of the number of wives, all the wives upon the death of the person concerned will take up 1 house together with all their children. If the
all
children
the spouses, the women,
yes,
they have to die for us to inherit some.
if the 4 of them have produced 36 children, so the 4 of them and the 36 children will just take 1 out of the 8
houses.
You get it. So there's some understandable unfairness in there, but that is the law as it stands. And so there's a coalition that is pushing for a replacement of the PNDC Law 111 that takes care of some of these things.
Okay. I think Mr. Emmanuel Abi would like to add something. I see that. Please kindly unmute and then make your submission, please. Emmanuel Abi, if you can hear me. Hello, Emmanuel.
Is it me or somebody else? I don't intend adding anything.
Oh, okay. There was on the question of 916, I was told that you would like to answer this question. So yes. Okay, okay. Okay, please, any other question? Is there any other question? Mr. Efa, any last words for us?
Oh, I will say that even though most of us here are young, in fact, we should take interest in issues of succession.
Right.
Succession. And I also will say, because we have reverend ministers amongst us, the church should take interest in educating our members on succession.
Right.
There are a lot of people, families have properties, and their parents acquire properties. As soon as the parents are dead, family members come in, they push the children aside, take over, and then the children go into, some become poor afterwards and are not able to achieve or reach their God-given potential. We should take interest. In the Bible, we see families. In fact, Jesus' genealogy is traced up to Abraham. I mean, there's proven record in the Bible that there's families, there are families and properties pass. So we shouldn't see, I think the notion or the current trend is that it's like, even if your father has 10 houses, I must also build my own. See? So we should be interested. We should take Accra lands are getting finished though. So a time will come, the only house you get is to remove the roof of your father's house and
build on top.
concrete it and build on top. So if we run away from our parents' properties because that's for our parents and our young ladies, please, when we are marrying, let's have all these things as part of it. The issue of, I don't want to be in your parents' house. I don't want to be in your family house. Let's build our own. Then we push ourselves sometimes into mortgages and we are paying, huge sums of money as monthly loan repayment. Meanwhile, you have your father's house sitting empty. Nobody is in it. So I think that when we were young, as Paul said, we were thinking like children. But now that we've seen certain things, we think that as a union, as a church, we should take interest in these things. You assess the situation. If it's inheritable, why not? Why go and start a new thing? Akufo-Addo is living in his father's house, even though he can put up several. So those are just my few words, that we should take interest in issues of succession. Properties of our parents will not just go to strangers and family members who knew nothing about the struggles. And simply because we are afraid, we think that these things are tainted with witchcraft and all. We Christians these days, we have all kinds of beliefs and things. Please, let's stop. Let's get more education. Let's take interest in succession so that we don't lose the properties that our parents are toiling to acquire for us.
Yeah. Thank you very much, Senior. Before Mr. Ndiansa, you give us your last words, there's another question. Why the special arrangements for those in the military and not, for instance, all those in the security services? What happens to those in the other security services? Why just the military?
Okay. Senior Dia will say something, but what I can say is that there is no explanation in the world. What we gather is that it is because they can go to war.
Yes.
So a military man during war could be shot, and before he or she dies, says to two other soldiers that, look, I have a house here and there. If I die, I give that house to maybe my first son or something. Because they go to war. I think that is the reason. But there's no formal reason in the law that this is the reason why the military have exception. but it's just generally they are the ones that go to war.
Yes, just yeah, it is what it is. I mean, and because they go to war, when you go to war, the probability that you come back is, I mean, the chances you cannot really determine. And so because, first of all, they also go to war to protect the state. So if Ghana is at war with another country, it is the military that are going to fight to protect all of us. So that special arrangement is made for them. But in addition, just in addition to what you have said, that's it. They are more likely to die unexpectedly, even though death cannot be predicted. But by the nature of their work, yeah, that special provision is made for them. Yeah, thank you.
Another last minute question. Can one contest a will? And if yes, what is the process? What process do you have to go through to contest a will?
Nadia, should I start? Yes, so that you conclude for us. Okay, yes, you can contest a will if you think that any of the legal requirements are not met. For instance, you think that at the time of the death of or at the time the will is alleged to have been made, the testator was not mentally sound. You knew that the person wasn't mentally sound. You know, normally when, assuming especially where the person lived a very successful life, you know, and acquired great wealth, properties. Normally, when they are not at that stage of life where they become mentally unsound and all that, the custom and what we do generally is to hide the person. We hide these people. Now, out of the blue, a certain will pops up and certain dispositions are in it. Now, if you believe that the person wasn't sound and could not have made that will, you can contest it. You think that even the signature on the will cannot be that of the person. That one, the Supreme Court's ruling on that issue is that a signature is any mark of the testator. But if you have, there's nothing like consistency of signature when it comes to wills. You can see that during the person's lifetime, he was signing this way. But you see, that being the law, if you have strong conviction that the testator did not even sign the will at all, that what is there was done by somebody not authorized by the testator, you can contest the will. If you think that the testator was illiterate and there is nothing on the face of the will showing that the will was read to the person before signing, because there was a deliberate attempt to mislead the illiterate testator so that the will was prepared. Oh, we've done your will, and then he signs. You can contest the will. So the very legal requirement that are needed to make the will valid are the very reasons you can contest the will. So those are, but not you know, some of the flimsy excuses and things. I don't like, so someone says, well, I don't understand why my father gave me the house in the hometown. Let's say your father comes from, let's find some village that will surprise you or shock you. You know? Yeah, something like that. And then your issue is that why did he give me the 3-bedroom house in that village and not the one at Sakumono in Accra here? I don't understand. Then you challenge the will. That's not an excuse. If you don't like it, rent it and use the proceeds to rent in Accra. So those kind of things are not. Why did he give me the Teshi property and not the Usu one? Why
did he give somebody who is not my sibling, like somebody you don't know at all in the family?
In the will. So there's a name in the will. You don't know that person as a family member. See, why is this person in the will? Those are not reasons to contest the will. If you are contesting a will, you are saying that the will is not valid. It was made when the testator was not sound, mentally sound. It wasn't signed by the testator. There were no witnesses. The will was signed under cover of darkness. There were no witnesses. Now, when you want to contest the will, you make an application to the High Court to challenge the will. You go by an application to the High Court to challenge the will. If probate had already been granted, you then issue a will suing the executor. You sue the executor by writ if the executor was already taking probate. And I mean, generally, when these things come up, you talk to a lawyer will know what to do.
Yes, yes. And now the last two questions. I see the questions are coming in now. Can one do a will without a property? And then, yes, can one do a will without a property? I think I'll merge that with the next question. And when the will is done, who keeps the will? The testator or the lawyer?
Okay. Yeah, I mean, the essence of the will is the property. So if there's no property, there's no will.
I'm
Yes,
sure the person is thinking
whole-
of landed property, maybe not just landed property.
Oh, no. Hey, any property is property. Please, your mobile phone is property. That iPhone you cherish so much is property. The charger is of the mobile phone is property. That money in the bank account is not much, but it's property. I mean, property is property. When the will is prepared, normally it's convention. We prepare the will in 4 copies. You take it to any High Court. The registry will seal the will. There's a way they seal the will so that if somebody opens it, it can be detected, because the will should not be opened until after the death of the person. And those of us that are aware of custom, even after the death of the person, normally the will is looked at after a year, after they celebrate the 1-year anniversary. But that is not law. It is just custom. Some people believe that it is after 1 year that the person now becomes ancestor. So that's the time. But the will be sealed when you take it to the High Court. 4 copies of that will plus 4 passport-sized pictures of the testator. You take it to the High Court, the will is sealed. And then the High Court will take 1 copy. After the sealing and registration, the High Court will take 1 copy and give 3 back to the testator or whoever deposited, whether the lawyer of the testator, a person authorized by the testator to go and do the deposit. 3 will be given back to you. The testator ordinarily will keep 1. Normally, the executor named in the will should be given a copy. You see, the reason for the remaining 3 is to let people know that the testator has made a will. So that when the testator dies, somebody can draw the family's attention that there's a will. So the 3 is given back to you. The testator is supposed to share it or give it to people who can alert the family when he or she is no more. So sometimes the lawyer who prepared the will is given a copy. The executor is given a copy, and the testator will keep a copy. But the whole essence of giving you the 3 is to let the family know or people know that you have made a will. So they shouldn't go ahead and deal with your property as if you didn't make a will.
Okay, thank you very much. Fabian, but the last question is, what will happen when the will is not deposited? If after the will is drafted, it's not deposited, does that invalidate the will?
No. If the will is not deposited, after it is found, anytime the will is found, it can be deposited.
Okay.
It will not invalidate it. Any time that the will is found, you just go to the High Court and deposit it. That's all.
Okay. Thank you very much. Mr. Duansa, any last words?
Yes. So maybe just a quick addition.
Okay.
You could, as we are ministers, as we are in the church, you could deposit, you could leave a copy of the will with maybe your months, not the months, I mean your church, maybe the church office, so that at least if you're a church person, the once you die, then they alert the family that you made a will and all that. Yes. And the last question about what was it? I think I had a quick comment. The one senior you answered, Chairman, you answered. The very last.
The last part 1. The one on who
depositing-
keeps the will?
Oh, depositing a will. Yeah. If it's not deposited, yeah.
Okay, if it's not deposited, yeah.
So once you find that the person made a will and maybe it was not deposited, even if the person dies today, has
Yeah.
died, and you later find it, you can still deposit it. What is
Okay.
important is that you see, you want it to go through the court system so that when they are reading it in the courts, at least it will be a level playing ground, more or less, so that in the presence of all key if you like key stakeholders who have been invited to listen to it, everybody hears it, and then on the face of it, once it satisfies the requirements of the law, it is valid. It's not because it was deposited after. It will not be invalid because it was deposited after the death of the testator. Yes.
Okay.
Yeah.
I know I said the
final-
last one. I've seen some questions. So last two, I think I've said because of time, we can't take more than this, but the last two, the first is on average, how much does it cost to prepare a will in Ghana? Last two, but there's extra questions coming in. On average, how much does it cost to prepare a will in Ghana? And then I'll
Okay.
take that together with when should one do a will? Is updating my will going to come with extra cost? And how many times can one update his will?
Okay. So on average, how much does it cost? The depositing at the High Court is 50 Ghana cedis.
That's easy.
That's the depositing. But the sealing of the will such that it cannot be opened depends. Some registries will charge you 20 cedis per envelope. Some will charge you 50 cedis per envelope. It depends on the registry and how much they bought their seal. So you can also buy the seal. You can look for the seal, buy it, seal it, or your lawyer can seal it before taking it to the High Court. Then the High Court, if they find that the sealing was properly done, will just register it and at the deposit, the 50 cedi cost. Yes. Then the legal fee depends on the lawyer preparing it. Yes, so it depends. It depends. So the legal fee is difficult to say. On the average, most young lawyers hungry. I mean, when you come out from, when you are called to the bar, preparing of wills and things are the initial
The bread and butter
steps
of the
yes. So I mean, 2,000. Yeah.
3,000.
If as and when the lawyer gets settled and things, 2,000. And then also it also depends on the properties involved. If it's a vast estate, definitely, I mean, the lawyer will charge more. If it's a vast estate, a lot of properties involved, a lot of trust. Like the estate is big, the testator has minor children and wants to create protection for these children.
Yeah.
Yes, the testator belongs to various associations and charitable groups that he wants to make donations to. All of those kind of wills with very complex structuring within the will are expensive. Expensive. But the normal ones that, I mean, 1,000, 2,000, you can get a friend to look at it. You can even prepare it yourself and go and deposit it. Yes. So that one.
But how many times?
You can, when the will is deposited, like I mentioned, you cannot make an insertion after the signature. You cannot make an insertion beneath the signature. So once it's deposited, that is it. But when you want to add or you want to make changes, you do it by a document called codicil. Codicil. You prepare a codicil. That is supplementary will, if you like, supplementary will, and indicate the changes you want to make in the main will and indicate additions you want to make. Let's say at the time you just had a house, you've built 2 more, you want to add that. So the codicil is a supplementary will which you do. It follows the same structure as the will, and then it is deposited in addition to the main will. But the best is just to redo the will entirely. You do the will afresh and withdraw the old will. That's all. Revoke the old will and go and withdraw the one you deposited at the High Court. You go by a letter. that I deposited my will, my name, I want it withdrawn from the High Court. They will give you the physical will. They will give it back to you. And then you now deposit the new one. But if you just want to make just an amendment, you prepare a codicil just like a will, and then you deposit that one. As many times as you want to do. I mean, there's no limit to the amendment.
Okay. Thank you very much, Senior. Mr. James, have you given us your last words?
I think someone asked, when should you prepare a will?
Yes, when should one prepare a will?
As soon as you get your first property, if you're above 18, as soon as you get your first property, you can decide to prepare a will to cover it. There's no age requirement. As and when you feel that, look, I have some properties that I want to take care of by way of a will, you do it.
Okay. I'm sure updating the will also come at a cost. Someone wanted to find out whether updating the will come at a cost.
Yes, when you go to deposit at the High Court, they will charge you the normal administrative fees. The legal fees, it depends on the lawyer you are working with.
Okay, thank you very much. Thank you. Senior, we've heard your last words, right? Mr.
Well,
I you have 30 seconds, please.
30 seconds, yes. I
Yes.
think these things are important. Sometimes you would want, I think it's probably you can die and sleep well when you have been able to determine who walks in your shoes. I think so. So I think it's important that we give some attention to these matters. And because for Nugin, I mean, we have members who are lawyers and things. Let's just get educated and get informed about these things so that, especially for those who are going through, issues, who have real needs, let's get education across, and then I'm sure it will be helpful. In fact, there's a lot in the church that we can all do. So I think if I mentioned earlier that for ministers amongst us and things like that, let's once in a while, let's bring up some of these legal education to our members, and then it will help a lot. Thank you.
Okay, thank you so much, Lawyer Duranstein, Lawyer Efa, for this insightful session. I'm very sure that everyone on the call has learned a lot. I think one of the things that I'll take away is the fact that we should take interest in issues of succession, and we shouldn't wait till we are old. We can start now. We can start at a young age, and we should take interest in the properties that belong to our parents or our elderly family members. I think that this is a wake-up call for the church to also get involved with sensitizing their members to take part in these things and be aware of the nitty-gritties that go into succession after a person has passed on, or even the preparation of wills. Thank you so much. And I think that this has enriched our bank of information. We are grateful. Thank you. I'll hand over to Manuel Labi to close us.
I want to thank everybody on this call this evening on behalf of the National Union of Presbyterian Students, Ghana, Nugin University of Ghana local alumni. Hopefully this will be the last session for this year. But then if there are specific topics of interest to members that they would want us to organize such fora on, feel free to reach out to either the executives or put it on the Nugin alumni platform. We'll pick it up and then organize such conversations around it. So I want to thank our panelists. I want to thank our hosts, Ayeyi. I want to thank Richard, and I want to thank Kennedy for the pro bono services you've offered us this evening, because we didn't pay the legal fees that you spoke about this evening. We are grateful for your time. Some people have asked, where do they find the recording? So we have recorded this. We're going to put it out as usual on the YouTube channel of the alumni platform, and then we will share the link on the alumni platform so that you can also disseminate it to your networks. I want to thank everybody on behalf of the alumni executives, and as the year draws to an end, wish everybody a Merry Christmas and then a very successful New Year 2024 and beyond. I see Reverend Dr. Reverend Professor Adubia on the call, and we humbly call upon her to give us the closing prayer and benediction.
Okay, thank you. I wanted to be very quiet, but I thank God I saw it like 2 minutes, actually 3 minutes before it came on. This is my first time of joining. I'm grateful. I'll work towards looking out for it and making time for it. I'm at a point that, based on some family experience, my sister just visited me, got sick, stroke, couldn't talk, say anything, just died. And so I'm dealing with all that as, okay, so if it were me, what would have happened? And I realized that it's time for me to do my will and tell people about my things and etc., etc. So I'm so grateful to God for this, and I thank God for everybody that he has used to bring this information to us. I'm also very grateful for seeing everyone, because there are some of you that haven't heard of or seen in years. And so, okay, we are praying. Father, we thank you so much for your goodness and your faithfulness to us. We are grateful for such knowledge. Indeed, you tell us to seek knowledge, to seek wisdom, to seek understanding. And we are grateful for our fellowship. We are grateful for your fellowship and for your calling to us. We are grateful for our people that you have endowed with such great knowledge. We are grateful for the programs that you have given us through the rest of the year, and for bringing us to this one as the end of our programs for the year. Grateful for our church. It's a great church. Grateful for our very lives and for everything. We are asking you to continue to be merciful unto us, to continue to hide us under your wings, to continue to draw us to yourselves, and continue to help us to respond to your love and your calling of grace on our lives. We are praying that you hide us under your wings, and by your mercies move us from 2023 to 2024. Father, help us to give forth our best to you and to our church. Bless our church, bless our homes, bless our families, and Father, indeed, remember us in all that we need. Bless Nupshin, help us in the name of Jesus the Lord. Amen. Please, I'm sure you are not hearing me, but let us all share the grace together. May the grace of
our Lord Jesus Christ, the love of God, and the fellowship of the Holy Spirit be with us now and forever. Amen.
Amen. The Lord bless us all and make his face shine upon us. Amen.
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 Thank you.
Hey, Senior Kwame JB.